Those of us who litigate know that writing is fundamental to everything that we do, because very much, most of the time, it's about the written record and it's about communicating your ideas clearly in writing.
While your madman is generating ideas, generating arguments, your judge is being overly critical of everything that comes out. Judges, clerks are very likely going to start with the opposition because that's really where the battle actually begins, right? That's really where the arguments against arbitration are going to appear.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Alfera Jansson and Michael Alfera. Alfera L. Jansson is a litigation associate in the Los Angeles office of Gibson, Dunn & Crutcher. She rejoined the firm in 2023 after serving as a judicial clerk for the Honorable Philip S. Gutierrez of the United States District Court for the Central District of California. Alfera earned her law degree summa cum laude from Southwestern Law School, where she has also worked as an adjunct professor teaching appellate litigation. Michael Alfera is a litigation attorney who excels in devising winning arguments and case strategies for clients involved in business and commercial disputes. Prior to working in private practice, he worked as a judicial law clerk, first up for the Los Angeles Superior Court and then for the Honorable Otis D. Wright II, District Judge in the District Court of the Central District of California. Working in the supporting role for multiple judges fostered Michael's ability to analyze cases from a judicial standpoint and to write with authority and persuasion. The webinar that you're about to watch will be approximately 2 hours, and Alfera and Michael will be taking questions from the audience once the webinar is complete. So if you have any questions along the way, feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen, and we will get to those once the presentation is complete. Now, without further ado, here are Alfera and Michael to discuss The Lawyer's Guide to Impactful Writing from Introduction to Conclusion.
All right. Good morning and good afternoon, everybody. Thank you, Nina. So once again, I'm Michael, and with my colleague Alfera, thank you all for showing up. We're looking forward to spending the next couple of hours to show you a little bit of what each of us know and have picked up about writing, about legal writing along the way. Just by way of a little more introduction, Alfera and I are both litigators, and those of us who litigate know that writing is fundamental to everything that we do, because very much, most of the time, it's about the written record and it's about communicating your ideas clearly in writing. So we both became interested in writing in law school. We were colleagues at Southwestern Law School together in various programs and things, and several years into our litigation careers, we're, still writing every single day and working very hard to become better at it in every way that we can. Alfera, anything else to add by way of introduction before we jump in here?
No, I will. I guess the only thing to add is part of Michael and my story is that we were in school together, but then we met back up and reconnected while we were both clerking at the Central District. And I think this is really the brainchild of a lot of those conversations, because both Michael and I tend to nerd out about writing process, and we're very process forward. And so this is really what the product of a lot of those conversations that we've had since clerking and through practice.
That's right. I think we were both very fortunate to work with some really, really skilled judges and supervising judicial law clerks that we both learned a lot from and learned from each other too. So let's hop in. We're going to start with the topic of the different stages of writing and how you can use your understanding of these stages of writing to overcome writer's block. And these stages are going to really form kind of a blueprint for how we approach everything for the next 2 hours. So Alfera, why don't you take it away?
So we are not reinventing the wheel. We are going to take from Betty Sue Flowers, who was a poet. She's an educator, an English professor at University of Texas, a former director of the LBJ Library. And Betty Flowers wrote an essay in 1979 that was called "The Madman, Architect, Carpenter, and Judge: Roles in the Writing Process." And one thing we just previewed, which is that brief writing is just as much about the process as it is about the final product. And one of the reasons for me that I am very process forward and I tend to spend quite a bit of time reflecting on my process is because the hardest part of writing, at least for me, but for many, is getting started. And if you have a process in place, something that you know you can replicate, it's going to change. It's also going to have to vary given time constraints. As we all know, we've all been part of instances where an ex parte has just landed and you have only a few hours to turn a draft opposition around. And so then you're not going to be able to think as much about the process of drafting in that case. But if you are thoughtful when you have opportunities to actually reflect on your writing process, if you take that time, then it's going to come in clutch when you have less time later. And so the whole point about these different roles in your writing process, Betty Flowers' essay was the idea that when you are stuck or when you have writer's block or how to get started, the reason you're struggling is because there's two competing energies and they're locked. Horn and horn pushing against each other. And we're going to call one of them your madman, and the other one we're going to call your judge. Your madman, and we're going to talk more about what the madman stage of the writing process is, but your madman is creative, at times frantic. Sometimes the writing's a bit sloppy. The ideas are disorganized. And your judge has a very clear sense of what the final product needs to look like. And so while your madman is generating ideas, generating arguments, your judge is being overly critical of everything that comes out. And so it actually stifles you as a writer. It stifles the process. It makes it almost impossible to push the writing process forward. And so Betty Flowers' essay and this whole concept, which many legal writers have taken and adopted, is we're going to introduce two personas into this process to give space between your madman and your judge. And in doing that, we're going to give time to each different role. So if we could turn to the next slide. Your madman, as I mentioned, can be frantic. It's filled with ideas. This is the early stage of your process. This is the generation stage of your process. And so they're going to have a whirlwind of ideas. You might be using mind maps, jotting down quotes. I don't know if any of you have gone down research rabbit holes. And part of that process is you just have a Word document where you're just dumping quotes from cases that you think could be helpful into this research document. It's disorganized, and you're also searching and investigating essentially without a clear path of exactly where you're going sometimes. Now, that's not always the case. There are times where your madman process might actually be quicker because this is a motion that you've done many times before. This is a set of facts you've seen many times before. But there's always that opportunity to find something novel, something that you actually haven't seen before, or an idea that you actually haven't explored yet. And so giving a bit of time here, or also, if there's even new case law that maybe changes something that you've done previously, that's where your madman comes in. And so one of the points of this process is it's messy, it can feel disorganized, but it's actually necessary. It is a necessary part of the process. It's actually the part I find to be the most uncomfortable. Of course, because as lawyers, we have limited time and we want to get to the end final product, but it is a crucial part that you have to give space to. If we can go to the next slide, this is where your architect comes in. Your architect is the one who comes in after you've given your madman an opportunity to generate. And this is all about organizing your ideas. This is where the emergence of arguments or rationale is going to appear. And they're going to bring order to the chaos. They're going to look and see all the different things that your madman has found, generated, the different ideas they've generated. And they're going to start to group them into similar ideas. Your architect is also going to start to eliminate the ideas that seem less persuasive, weaker, that don't quite frankly fit into the overall structure. And most importantly, your architect is going to outline and create the bones of your brief, your motion, whatever it is. Next is your carpenter. Your carpenter is there to build walls, put in floors, make a roof. So this is where actual sentence structure is going to really appear, and where you're going to start to see some logical flow. There are different thoughts on what the carpenter should be. So if you have really given time to your madman and your architect, the truth is your carpenter is going to be able to come in, and a lot, there is theories that you should just write your first draft quickly without stopping or self-editing. And that's the first stage. That's the first part of your carpenter stage. The problem is if you have shortcutted the madman, or most importantly, if you've actually shortcutted your architect, you're going to find that your madman creeps in a lot more into your carpenter phase. That's okay. That sometimes happens. This is why I always say the best part about your process is just being self-reflective and thinking through, I didn't actually give enough time to outlining previously. And so that's partially why the carpenter phase maybe seemed a bit more difficult than it may in other situations where you do give more time to the organization and outlining phase. And so the whole point of the carpenter is to actually produce your first draft and truly to have a clean draft. I would say to worry less about persuasiveness or worry less about the flourish, because that's going to come next when we get to our judge. And so at the very beginning of the stage, or at the stage of your writing process, right? This is what Betty Flowers was talking about, is your judge was trying to get involved, trying to step in on your madman and tell your madman that no, they're not creating the work product that they need to be creating. And so when you tell your judge to step away, you're promising them that they get to come back. And this is when your judge comes back in, and it's to critically review the work of the carpenter, refine the sentences, refine word choice, ensure that the arguments are clear and persuasive, bring in theme and narrative. And then also, which we're going to be talking quite a bit about, consider your audience and revise your work product to target that audience.
All right. Our next topic here is understanding your audience and avoiding common chambers pet peeves. Before I jump into this, I just want to sort of pause and address for a second the question of, who exactly is this presentation for, and what kind of writing are we really talking about here? Because Erica, correct me if I'm wrong, but the Betty Flowers model was not a model specifically for legal writing, correct? It was just a model for writing fiction or nonfiction, correct? Yeah.
Absolutely.
Yes.
Yeah.
And so, this, whatever kind of writing anybody who's out there tuning in does, this paradigm is really, really helpful for setting out those phases and letting each of these things sort of happen. But, I think this presentation primarily is focused on folks who are writing briefs for neutrals who are then going to read those briefs and have to make a decision. But as you'll see along the way, there's a lot of things we'll discuss that are quite universal to legal writing and then to writing in general. So with that said, we're going to talk about understanding your audience. We're going to focus specifically on what that audience looks like when it is a chambers or a neutral, but the principles can be applied to any sort of audience that you might have. So right off the bat, the question is, who are you writing for? Or you could rewrite that sentence, for whom are you writing? And depending on who you are writing for, you might use the first sentence or the second one, right? If you are writing for an esteemed appellate court where, language is, everybody's taking a lot of time and the language really matters, you might be a little more formal and keep your prepositions out of the ends of your sentences. And you might use a more formal sentence structure. State court probably doesn't matter so much. But let's get into more detail about who these audiences are and how they're looking at your writing, because this informs the entire process from the ground up. So judges have different approaches to decision making, and it falls along a spectrum. So one spectrum of different approaches to decision making is the results driven approach versus the law driven approach. You know, you have some judges that are very sort of results driven. I believe that Judge Posner was one of the judges who wrote about this. That his approach was to start sort of very top down, look at the dispute, look at the disagreement, look at what's being asked for, and say, what is a logical, sensible way to resolve this dispute and move on in a way that benefits the parties? And then from there, beginning to add legal understandings and legal structures and legal frameworks to justify this decision. So that's a very results-driven approach on one end of the spectrum. The other end of the spectrum is the sort of more bottom-up approach, the law-driven approach. Judges and neutrals who really start from the basic principles, and then through a series of if-thens and a series of logical propositions, and we'll actually get into some of that a little bit later, build up from the law to determine what the resolution of the dispute is going to be. And of course, to the extent you have the ability to, it's great to be able to research your judge. You know, our legal databases make this relatively straightforward nowadays, including for a lot of state court judges. You can look up a certain type of motion and see how the judge has thought about that. And sometimes you don't even need to do that. You know, sometimes for me, if I'm sitting in on a hearing, waiting for my number to be called, sometimes it can just be really helpful to just listen very carefully to how that judge is talking to the other parties. What seems to be important to that judge? Is this judge really sort of by the book and formalistic and going from the bottom up? Or is this judge really just trying to get more of the gestalt of the matter and move forward with the decision that way? Another spectrum that exists in terms of how judges make decisions is this one on the bottom right here: party presentation principle versus Chambers research. So the party presentation principle is this idea that the courts are supposed to be essentially selecting between the stronger of the two arguments that are presented to the court by the attorneys. That it is the attorneys who are the master of their clients' cases, and it is the attorneys who are best equipped to understand which arguments are best to bring before the court and which are not. And so a judge or a neutral that very strictly follows the party presentation principle is really just going to be making decisions solely on the basis of comparing the two parties' arguments, assessing their relative strength, and selecting the one that is stronger. Interestingly, there's an opinion shortly before Justice Ginsburg passed that she penned, and it points out that this is actually an issue on which Justice Ginsburg and Justice Scalia agreed. So I think that's kind of interesting. They both believe that justice is best served when judges follow the party presentation principle. And sometimes you see cases get overturned at the appellate level because a judge strayed too far outside of that principle. Okay, so what is the other end of that spectrum then? I call it Chambers research here. Well, Chambers are always going to be doing research. They shouldn't not do research, obviously. Chambers is going to do legal research. But what I really meant by that is, to what extent is the Chambers or the neutral going beyond the argument that the party simply presented to make its own observation, its own sort of maybe factual assertion or legal conclusion that wasn't necessarily in the papers, but it's just something that the judge saw. I personally, I think a lot of us might have some examples from our own practice of where we were surprised that a judge didn't follow the party presentation principle. And this can work, in my experience, this has both worked to my benefit and against my benefit. There have been times when the judge kind of went outside anything that I put in the papers and rendered a decision in my client's favor based on a point that I didn't exactly make. There have also been times when the judge sided with the other side because of a point that they didn't make, which can be particularly frustrating because then, of course, this brings up some potential due process issues of, hey, did I really have a chance to respond to the argument. So anyway, it's the overall point of this slide is it's important to keep in mind that there are different approaches to decision making, and to the extent that you can find that you can get a sense of how your neutral approaches it, great. But also writing from the perspective of there may be multiple folks looking at your matter who all have different approaches to decision making. So how can we make our writing reflect and work with all these different kinds of approaches? So when you're writing for legal filing, of course, you're never just writing for just the judge. You're writing for all the judge's staff who is also going to be reading your writing. And let's talk about that person. Your judge's law clerk or research attorney. What is the typical profile of this person? And Erica, I think I'm going to pass this off to you.
Great. So one of the reasons I will just flag, this is not it doesn't go across all cases, but one of the reasons you actually might have a judge that strays a bit from the party presentation principle is because oftentimes you have a law clerk, and the law clerk is the first person who is touching your papers, and they are eager and excited and they want to get it right. And so this is actually, I think, sometimes where that truly happens. An important part of writing that I always remember, and this is, I think, one of the values of this presentation, is you're hearing from two people who are in litigation, but also worked on the inside. And so can kind of pull back the curtain just a bit. And when you are writing, you have to remember that you are writing for the law clerk to a certain extent, because they are the ones who are most likely the first to touch your brief, the first to touch your motion. And so it doesn't matter if your case has been before this judge for 2 or 3 years or longer, because in some instances, unless it is a term clerk, you have a law clerk who is cycling out every year, every 2 years, usually at most. And so this is a person, they are usually right out of law school, at most 2 years out of law school. So they're fresh. They probably haven't seen a good chunk, if any, of the motions that are coming before them. And that means you need to be careful not to just assume that your reader knows the case, or assume that your reader knows the law. This might be the most standard discovery motion, but still, this could be brand new. And it's especially true if you think about how oftentimes clerk cycles work. It's especially true if you are in the end of summer, beginning of fall. That is oftentimes when clerks are cycling out. So that could actually be to your benefit. For example, if you got a really bizarre ruling on a motion to dismiss or a motion for summary judgment and it's August, maybe this actually is the right time to file that motion for reconsideration that never quite gets treated seriously, because just maybe you're going to actually have a new set of eyes looking at your papers, and they might pick up on a mistake that the clerk before them made. And the other thing to think about is there's different chambers dynamics. So it's not to say that that the law clerk is the only one who touches the papers, or that the judge doesn't have any oversight or say in what the clerk is recommending, or what the final decision is. But the clerk's initial recommendation carries weight to a judge, usually in most situations. And again, a judge might ultimately veto that and say, no, this really makes the most sense, or I'm looking at the law, I don't agree with this analysis. But that initial recommendation, try to get the clerk on your side, because if you can have an advocate in the chambers right at the outset that is pushing for your position, that's incredibly valuable, and that does carry weight. So there are different dynamics. In every instance, you're going to have a judge that relies on their clerk. For some motions, the judge might truly defer to the clerk. Take this, work it up, and let me look at it. In other instances, the judge might think that what happens here is significant. You could see that happening perhaps on a specifically summary judgment motion, where some issues are going to be taken off before it goes to trial. And so the judge might be a lot more hands-on. It depends. And so it depends. But in either case, I go back to the point I just made, you want to have that advocate in chambers for you. So keep it simple, keep it clear, and don't play inside baseball because you want to get the clerk on your side. Make it easy for the clerk to understand your position and make it easy for them to want to side with you.
One thing I want to add, because these are all really good points, something you said a moment ago, Erica, that this law clerk who's reading your papers might be the first papers from your case that the law clerk has read. And I think it's important to point out that even if a judge has seen papers from your case before, generally, and this is certainly true of state court, but it is very true of federal court too. I think a lot of litigators assume that as time goes on, each judge forms this overall map or opinion in their heads of what the case is based on prior briefings and prior filings and prior hearings and how things have gone. Now, that may be true of, say, some arbitrator, a private arbitrator who has a very small case range and who can keep their 10 or 12 cases in their head. But for example, in Los Angeles Superior Court, where Erica and I often practice, judges have 500 to 600 cases in their case range at any given time. They don't have a blueprint in their head of any given case. They are looking at the papers before them and making a decision based on the narrow universe of information that is put before them. And in fact, there was a great article by a federal district judge recently that was published in the ABA journal, where the judge talked about this, and he actually really wanted to broadcast this message out to attorneys. He says, and this was sort of in the context of the judge saying, there's this practice where litigators want to be the first to file the first discovery motion to sort of take over the narrative of the case and move it along. This judge says that's not really reflective of the reality of how a chambers works. Judges aren't really thinking from one motion. Oh yeah, I read that motion 3 months ago, and let me think about what that motion said and compare it to that. That's just not how it is. The judge and the law clerks are looking at the stack of papers that constitutes the motion you're putting in front of them. So again, this is your audience. This informs how you write. You certainly don't make assumptions that the person picking up your papers knows the facts of the case or knows what's going on, right? And then, of course, the last but certainly not least audience member is your client, right? Typically, this is the person who is paying you to do all of this writing, right? And there's different types of clients, right? You've got corporate clients for whom the bottom line is the most important, and you've got individual clients for whom there's maybe a lot more nuanced type of dynamics, and there's interpersonal dynamics, and there's different things going on, And for some clients, and this is very fulfilling for me as an attorney when this happens, the experience of having a person such as an attorney wrap their head around the person's issue and create a persuasive and powerful verbal statement of it on paper can actually be a very validating and vindicating process for a litigant who has been in a dispute with somebody for a very long time. And your clients best, and what it is your clients are hoping to get from a briefing. So the client and the client's needs are another thing to keep in mind. One more aspect of keeping in mind your audience is considering which court you are writing for. Now this is a very rough ordering, and how do we put them in order here? This is our very rough order of the top of this list is courts that are most likely to spend the most time looking at your papers. And then the further down you go, you get situations where the courts are less and less likely to spend a lot of time looking at your papers. So obviously in appeals court, everything you file is going to get read. The clerks there have, in some cases, multiple weeks to look at one case, and is expected that everything's going to be looked at in very, very careful detail, because that's the point of the appellate court, right? To seek out and correct errors. Moving down from there, you've got federal specialty courts. I've appeared in bankruptcy court a few times. I'm not a bankruptcy attorney, but I'm a business and commercial litigator, and so we end up in bankruptcy court sometimes. And I'm always amazed at how those bankruptcy judges really do seem to have read every single piece of paper, every single declaration, and looked in every single exhibit, and you very often have them in their mind and are able to discuss them. Federal district courts may be a little bit busier, but you might expect, depending on how busy the chambers is, a law clerk might spend 3 to 5 days on an MSJ, maybe 3-ish days on the 12B6 motion to dismiss, something like that. So there's a little more time there. And then, state court, as you go further down, and then of course it can be very county specific and jurisdiction specific as well. But it's very often the case that there's not a lot of time for the judges and the law clerks, and that a lot of times, especially for matters and motions that are very routine and that the law clerk or the judge sees a lot, there's often a formula that they'll approach them by so that they can crank it out and get going. So MSJs or demurs, we call them in California, 12B6 motions to dismiss. Really, those might get the most time. But certainly, as a Los Angeles Superior Court research attorney, my average amount of time for working up an MSJ workup was 1 day, which can really surprise folks. Obviously, when you compare it to exactly how much time you're spending putting the darn thing together, right? Discovery motions, of course, there'll be less time spent on those. And then obviously ex parte applications, because of the extremely truncated process that the relief is being asked for. Sometimes those just get one quick read. And this point really can't be overstated. I have colleagues I remember from Superior Court who, they worked in, there used to be a personal injury hub at LA Superior Court where all the PI cases would go through. And I believe they've wrapped that up in the past few years. But when it existed, there would be situations where the research attorneys assigned to the PI hub would get 10 or 12 discovery motions dropped on their desk in the morning and be asked to have a workup for all of them by the end of the workday. So again, informing how you write, informing what is important and what isn't, right?
And I have one thing I just wanted to add, 'cause this ties together with the ex parte application and thinking about who your audience is. So in the court, we oftentimes see ex parte applications filed, and I think when you are a litigator, you're thinking about it as a tactic. You file it on for example, Friday afternoon, and you're doing it in some ways to tank your opponent's weekend. Remember that you're also tanking your judge and your clerk's weekend as well, and really most likely the clerk's weekend. So you want to be strategic in those moments. Is this really an ex parte motion that I need to file? If you have somebody who's on life support and they're about to pull the plug on Saturday morning, well, of course, or on Monday, of course you need to file that immediately. Of course, that is something that is so time sensitive that needs to go, that you need to file the ex parte. But if this is an ex parte that, quite frankly, doesn't need to happen over a weekend, maybe you want to be strategic, because you might actually be filing that and in the process pissing off your, excuse my language, but upsetting your clerk, upsetting your judge. And then if you actually need to file an ex parte later down the road, truly because something has come up and it's an emergency, well, you've also lost a little bit of that goodwill in the bank. So part of this is to remember that who your audience is, how much they're actually giving to your papers, and that when you're filing these papers, it's not only about the strategy between you and opposing counsel, right? You want to keep in mind what this paper is actually doing to the reader and the person who's going to have to do the workup of the order.
In other words, don't be the lawyer who cries wolf, because when
True.
it comes time to need to actually cry wolf, you're going to have bad time. Okay, so you want to take this slide and I'll do the next one, because this is a sort of continuation of what we were just talking about. Okay, we know that the judges are busy. We know that the law clerks are busy. Okay, so what are they doing to be efficient? You want to take this one?
Sure. And so to play off of this, a lot of times at the court, because you're so busy, because you have such a heavy docket and there's a lot of motions, clerks and judges are looking for the fastest way to resolve the issue. What is the path of least resistance? And so it's important when you are going into a motion, when you are opposing a motion, to think about what is the path of least resistance for the judge? And at least keep that in mind. It doesn't necessarily mean that you shouldn't file the motion. It doesn't mean that you shouldn't file an opposition, but you want to be aware of it so you at least know how much you're going to have to make up if you are the one who is actually asking for something that is the path of greater resistance. Just as a clear example, it is oftentimes the path of resistance to deny a motion to dismiss unless the law is very clear, right? It is very difficult, or not very difficult, but it is difficult to find a way that the facts aren't sufficiently alleged to support a claim. So if you're attacking facts, well, that is certainly going to be the path of most resistance on a motion to dismiss. For summary judgment, another example, it's a lot easier, path of least resistance, to say that there's a reasonable dispute of a material fact and to deny summary judgment than it is to say that there is no reasonable dispute. And again, we're talking about factual disputes versus the law, but keeping that in mind is going to inform how much more work you need to put into and do to convince your reader. We also want to flag the different approaches that clerks, judges take when reading papers, because this might inform what you do or don't do. Everybody is different. And every motion is also different. So there are certain motions. I think one of the examples that Michael and I oftentimes have talked about is if you're filing, for example, a motion to compel arbitration, judges, clerks are very likely going to start with the opposition, because that's really where the battle actually begins, right? That's really where the arguments against arbitration are going to appear. And so it's going to be the opposition and the reply. That's going to be the central papers right there. And so oftentimes your judge or your clerk might start the opposition and then the reply and then go back to the motion. So that's really important to know. If you are writing the opposition, they maybe haven't read the facts of the motion yet. And so you might actually be the one to first present the facts of the case, the facts of the dispute, as well as of the arbitration agreement. You might get that first ability to paint the picture. I tend to be a bit more linear most of the time. I tended to be a bit more linear when I was a clerk most of the time. And I usually started from beginning to end. But I always looked at the table of contents for all the briefs first. And the point was, I just was trying to understand, what's the argument here? What's the basic organization? And it wasn't dispositive, but if your table of contents was a mess, if I couldn't understand the argument from your table of contents at a first glance, I already was a bit frustrated as a clerk. Again, was that dispositive? Absolutely not. But it's all about first impression. Where is that first impression coming from? Sometimes it's the opposition that is giving the first impression. Sometimes it's it's starting from beginning to end at the motion. I know that there are some clerks who immediately just jump into the argument. They don't even worry about the facts and just jump straight into the argument of motions. Michael, what was your approach?
Well, it would actually, we'll just use this opportunity to jump ahead a couple slides, then we can double back, because but this is great. This is exactly what we're talking about. And it really depends on the type of motion and the type of things that you have before you. So, of course, there are exceptions to that arbitration thing, and the arbitration example that you just gave. And one example that comes to mind is if there's a non-signatory agreement, if the party attempting to compel arbitration clearly has a hurdle because the party compelling is not one of the parties on the signed arbitration agreement. Okay, I'll probably start with the motion first because they have a burden to address that non-signatory issue. But, for example, for a lot of employment arbitration agreements, the motions might as well be templates in those cases. The employer is always going to say, here's the agreement, the employee signed it, therefore this goes to arbitration. And then, like you said, Erica, the interesting stuff starts happening in the opposition there. Different motions have different additional material filing requirements. In California court, we have a discovery separate statement requirement. This is not the same as your federal 2-column separate statement that you see in MSJs, where you see if there's a undisputed fact, and then the other column is the facts in dispute. A discovery separate statement is more just here's the request, here's the response, here's the moving party's reason why more response is required, here's the opposing party's reason why it's not. And so many times for discovery motions, the separate statement is the guidepost. It's what we start with, it's what we end with, and it's how we structure the workup, right? And actually, just as a quick aside for discovery motions, I think that's a point really worth making here, because it's a point about the audience, and it's also a point about how the decisions are being made. Ultimately, your judge, your neutral, has to go through however many if you're the moving party asking for more discovery responses, the neutral ultimately has to go through and make a yes or no decision as to each individual item that you are presenting before that judge, which I think is why some folks eventually, at the California Judicial Council, or wherever it was, thought, hey, let's force parties to make a request by request argument by imposing this separate statement requirement. But even if your jurisdiction doesn't have a separate statement requirement, when you're doing those discovery motions, keep that in mind. And if you're going to be batching your arguments, make crystal clear which arguments go to which discovery items, which numbers. And frankly, that was part of the reason why I, as a clerk, would sometimes go to the separate statement first, because I'd read the papers and I'd be even more confused because I wasn't sure which arguments were going to which requests, and therefore, how do I recommend to the judge which way it goes, right? So that's a little bit of insight into how those get looked at. And then I've put down here as the last one for Rule 12b6 motions or demurs that we say in California. Not always, but certainly for matters that we end up seeing a lot of. So one immediately comes to mind is the lemon law cases. And one of the big questions that comes to mind is, did the plaintiff sufficiently allege in detail the defect in the vehicle and the resulting safety or operability issue? And if it's just like transmission issues, okay, probably not enough. And I can just kind of go to the complaint. I don't need to read the papers back and forth because I've done enough of those. I understand what the standard is there. But, do keep in mind that and that would also often be the case for, employment discrimination, harassment, retaliation. We know what these definitions are, and we've done enough. The clerks typically done enough of them. The judges certainly have. There's almost a smell test. You look at the complaint and you can tell whether it has sufficient facts. I remember there was this one employment discrimination complaint that I helped with a judge with once. It was 53 pages. It was 53-page employment discrimination complaint, and it did not have a single case-specific fact anywhere in the 53. It was remarkable, to be perfectly honest, but it definitely got the demur was sustained, which is to say, dismissed with leave to amend, and the judge said, hey, you got to add some facts in. So those are some motion-specific examples. Did you want to talk about the legal standards a bit? Because this is also in the topic of who is your audience? Don't waste space if you know who your audience is. You want to give it a try? You want to take this over?
Yes, I'll take this. So there are some common pitfalls for legal standards. The legal standards should be short. They should be sweet. The truth is, oftentimes these are boilerplate, right? Certainly at the court, we have templates for our legal standards. And if you actually look through a judge's orders, oftentimes at the district court level, for sure, you're going to see the same standard reappear over and over and over again based on the type of motion it is. So I wouldn't put too much into that legal standard. Keep it short, keep it sweet. Don't waste your space, because oftentimes that's not being read. And let's say it's a common motion, like a motion to dismiss, but there are unique rules associated given the area of the law. You might actually want to reserve those standards for the body of the motion, because if you put it up into the legal standard, let's say you're taking a unique area of the law, such as antitrust, which has certain rules about what needs to be pled to prove up your section 1 point. Well, if you bury it in the legal standard, your judge or clerk might not have looked at it. And now they're getting down into your argument and they don't know what you previously said about that. So save more unique rules, more unique standards for your body, and let the legal standard be simple. Do you have anything, Michael, you want to add on that point?
Yeah, more relatedly than specifically about legal standard, but since we're talking about the legal standard section, I wanted to pause and let's zoom out and talk about what I consider the 5 canonical sections of a brief / a judge's workup. So one of the principles that I try to approach my persuasive legal briefing with is, in an ideal world, this brief that I'm writing, the judge agrees with it so much that they're just gonna copy and paste it into their workup and change the court should deny or the court should grant to the court grants or the court denies. Now, that is an ideal. Obviously, that's never going to happen in real life. But the way that plays out for me is, for example, in federal district court in the Central District, you go ahead and look at any of the workups, 90+% of the workups that come into the Central District of California have 5 Roman numeral sections. And those are introduction, background, legal standard, argument or discussion, and then conclusion. And the background can sometimes be split up into procedural, well, the factual background and then procedural background. But those are the 5 sections. And so if I know I'm in a jurisdiction where a lot of the workups end up having those 5 sections, why not? Right? Your law clerk and judge are already each day thinking about how they need to write their workups to conform to those 5 sections. Make it easier, right? Make it easier for them. And these 5 sections are really good because they really force you to think legally, which is to say, think about applying the law to the facts, setting forth the facts, setting forth the law, and then applying them. And so when you force yourself to truly separate your background section, that's your 2nd Roman numeral, and your argument or discussion section, that's your 4th Roman numeral, and really making sure the facts are the facts and the argument is the argument, it can force you to really clarify your ideas, and it actually makes it more powerful. Because if you're bouncing back and forth between fact, argument, fact, argument, fact, argument, you're kind of just going in a circle and not really gaining any upward momentum. But there's a way to lay out all the facts, shaded in your client's favor, but not outwardly argumentatively. And then once those are all laid out, then you go do your perfect 10 of the argument and start stitching them all together. And we're actually going to look into some of this in more detail. But I think our next topic is themes. Okay, so thinking back to the 4 stages that Erica so wonderfully laid out for us, coming up with and honing your theme is really mostly a Madman and a little bit architect type of work going on right here. So this is early on in your writing when you're looking for the theme and you're going to use this theme to build the rest of the brief around. So what is the purpose of a theme? Why even think about it? Why can't we just write what we want and go for it? Well, you as the writer, when you know what the overall theme of your brief is, it focuses you, and it makes sure that it gives you a guidepost, and it lets you ask yourself, as to every section, every paragraph, every sentence, how does this relate to my overall theme that I'm trying to communicate? If it doesn't, maybe it's a candidate to be trimmed. Maybe it doesn't need to be in there, right? When you have a theme, it helps determine the structure of your brief, and it assists with paragraphing. We'll talk about that a little bit too, because paragraphing is really about fundamentally is about knowing what the topic sentence of each of your paragraphs is. And when you're able to link those topic sentences back to your theme, you build a really tight brief where everything matters and nothing is wasted. So it gives the reader a definite takeaway. This is to me, frankly, the most important reason to have a theme. Again, your judges, your law clerks, they're buried in paperwork every day, and they've got to read a lot of things really quickly, and they're going to read your brief, and they're not going to remember every single nuance from all 15 to 25 pages, however long it is. But if you weave a cogent, powerful, ideally unassailable theme throughout your brief, it's what they will take away. So I'm a musician from my prior career as a classical pianist and a few other things. So I love working musical examples into my legal work. And I think that if you think about the way that a musical theme in a movie soundtrack works, it is perfectly analogous to how the theme of a brief works. And my good example that I think most of us, I like to think at least most of us might know, the musical theme from Jurassic Park. Now, I haven't seen that movie in years, but the moment I say that, I can hear it in my head, and I can hear exactly what it sounds like, at least the first few seconds of it, right? Now, if you asked me, hum literally any other melody from the Jurassic Park soundtrack, I would not be able to do it for you. But that's the power of the theme, right? It's still there years later. And so the same concept applies with your briefs. By contrast, what happens without a theme? Well, your brief lacks direction. It's harder for you as a writer because it's harder for you to assess what is important and what's not. It's harder for you to assess your overall structure. How are these paragraphs building up to my theme and supporting my theme, right? Without a theme, it's harder for your reader to contextualize. They might be, following you on some subsidiary point that you're making, but if you haven't given them the coat rack to hang the coat on, as it were, then it's going to be harder for them to understand why you're making that subsidiary point. But if you lay out your theme clearly, the reader will be making that connection in their own mind. And now you've got the reader thinking through your own thoughts and doing their own conclusions and doing their own logical thing about it. And that's exactly what you want. You want your readers' neurons firing on all cylinders when they're reading for you. So, you almost make it a little detective game for them, right? So that they understand where you're going. Without a theme, obviously there's no takeaway. The musical analogy would be, a big rambling 12-minute melody that doesn't really have any repetition, doesn't really, no themes come back, no melodies repeat. It's just a rambling theme. You might enjoy yourself, but you're not going to have a takeaway. Most likely it's going to be very difficult to have a clear impression of what you're taking away in your mind after that kind of rambling. This is Erica's expertise right here. This is a great approach for how to discover a theme.
So before I go to this, and this is Aristotle's triangle. I want to also just piggyback on one thing that Michael said, which is that your theme, thinking about your theme, is something that's going to start at the very beginning. It's going to start in your Madman phase. It's going to be there and present in your architect phase. A part of your Carpenter phase is balancing clarity and making sure that there is clarity and logical flow. And so it's okay in your first draft if your theme actually, if you focus less on your theme and you focus more on getting out clear, concise arguments, because that's also where your judge comes back in. And that's part of the role of the judge, is to make sure that the theme that you, or the narrative that you were working up as Madman, as your architect, it comes back in at the end. Because if it comes in too soon, or if you're prioritizing it too soon in the Carpenter phase, you'll end up with a bit of a mishmash of your arguments and your theme. It's really important to have the base, your foundation of a clean argument, to then overlay the strong, powerful, persuasive theme. And so part of discovering your theme, we have a few different ideas that we're going to be throwing your way to think about. Now, Aristotle's triangle is actually just elements of all persuasive writing. And so talking out this, I'm going to start with the bottom corner, your logos. And so that is your theme, but it's about, is it supported by clear reasoning, by the law? Sachs. Logos is all about logic and reasoning. If we move over to the other side of the base, we have pathos. Pathos is the emotional impact, the personal connection. If you practice personal injury, I'm sure that pathos comes up quite a bit in your writing. You're right. If you're talking about a person who was injured, and then the top of the pyramid is ethos. That's your credibility, your authority, your tone. Now, all persuasive writing has all three of these elements. Even if you think your case, even if you practice, I'm in corporate litigation, and so sometimes you might think that there is no, it can feel like there's no pathos. No, there is pathos. You find a way to build in the pathos if it's saying that the company you represent is doing something good. They have a good service. They have a good product that is helping consumers, helping society. This is the example of pathos. But your theme wants to have all components. Sometimes you're going to have a bit more logos. You're going to have a bit more ethos if the law is especially on your side, true law on your side, and it demands a certain outcome. Then your theme might be a lot more driven by ethos than pathos, for example. But part of identifying a good theme is that you're going to see all three of these appear. If you have to abandon, for example, your ethos, you have to completely abandon the law and abandon logos, abandon the facts in order for you to present your theme, then maybe you've picked the wrong theme. And we're going to talk about this also more as we get to the facts, but when we get to drafting fact sections. But part of building out the right theme is that all three of these are going to sing. Even if one sings a little bit more than the other, they're all three going to be present, and they're all three going to sing in their own way. And then another part of discovering your theme, and I can do the past, present, future, Michael, and you can then take the others, is thinking about a judge when they are deciding a case has essentially three judicial fears. And I'm stealing from Ross Cooperman, who wrote Point Made, and I think he really spelled this out beautifully. There's three judicial fears at play. There's the past. What is the law? The fear of misconstruing the law. There's the present, the fear of reaching an unfair result between the parties. And then there's the future, the fear of creating new duties, opening the floodgates. And so if I take each one of these, I'll give you an example of ways that you can play on these judicial fears and how some of these fears can actually be a significant theme. So an example is playing on, if it's about the past, playing on stare decisis, being very clear, this is the law, or emphasize why a law or a statute exists and how a ruling for the other side will completely undermine the very purpose of that statute. For a fear of creating new duties, for example, if you're thinking about the future, sometimes this might come up where you're saying, even if you are trying to reach a fair result between the parties here, the rule you will create will have an effect that will be broad and far-reaching and is going to be applied in other instances where it's not just going to be about these two parties. And so you are going to be opening up defendants or opening up companies, employers, whatever area of the law it is you practice, you're going to be opening them up to a whole new set of duties, a whole new set of responsibilities, and a whole new set of liability. And so it's there's a bit of warning there. And then, of course, when we're talking about the parties here, there's the simple theme of just fundamental fairness and describing the dispute in a way that you explain, if you want to rule in our favor, you want to rule in my client's favor, because that will be fundamentally fair given what has happened between the parties. And so that's one other way of discovering your theme, or even discovering a sub-theme of your writing and how you play on that.
Right. And there's just other different ways of exploring it and figuring out really where you're going and what the kernel of the argument is. The first reaction approach, it's actually really simple, but it's very effective in a lot of ways. This works a lot of times when you are needing to draft an opposition to something that just came in. Maybe you're about to think about drafting a motion to dismiss a complaint. But it's kind of that first gut thing, the opposing side's brief comes in, you read it and goes, and they're asking for the court to grant some sort of crazy relief, and you go, well, that's a bunch of malarkey because blah. And whatever just comes out, tip of the thought, can sometimes be, the little light down the pathway that illuminates to where that theme is, because that gut reaction oftentimes is very valuable, and we want to, honor and encourage that because it can really lead to some really helpful results. Free writing and free speaking, just kind of taking the topic and just beginning to stream of conscious about it, seeing what comes out, exploring what ideas get developed in your head when you're forced to sort of slow them down to writing speed. If writing isn't your thing, you can speak, speaking with another colleague, just having a really focused back and forth about, okay, what are we trying to get? Why? What's the point here? That can really help. And then Erica alluded to this a little while ago. And yes, I did mention that theme can be a sort of early phase kind of a thing as you begin to think about what you're writing about. But theme also focusing on the theme can be a late stage thing in your writing too. It's perfectly legitimate and valid to write an entire first draft of the brief and not really know what your theme is. You write the other sections first, and you see what begins to bubble up to the surface. And if you find yourself making one particular powerful point over and over again, there you go. That might be your theme. And then you want to sort of make sure that you've made use of that theme. So let's look at an example. This is sort of the last thing we'll talk about with theme, and then we'll go on to our next topic. So this actually is an introductory paragraph with, details change. This is an introductory paragraph from a brief that our firm wrote for a post-judgment situation. We are the judgment creditor. We were successful at getting a money judgment against this company, and we wanted to get an order from the court to allow a sheriff levy to go collect the assets. And so the theme of this is what you can kind of see highlighted in yellow here. This is the introduction, and the theme that we're starting to build throughout the brief is judicial intervention is necessary to preserve the judgment creditor, as that's our client's only practical avenue for repayment of the debt. And sort of this penultimate part of the introductory paragraph is oftentimes a very, very nice sweet spot place to put your theme for the very first time. You lay out what's going on, you hit the theme, and then you say, the court must grant this relief. The court must deny this relief, right? This later on is this is an ex parte application. So we had to show exigency. And this is from the section of the brief about exigency. And the theme is good, right? Because the theme speaks to the substance of what we're asking for, and also speaks to the exigency, which we have to show in the ex parte application, right? And that gets back to the pathos, logos, ethos, right? You want to make sure your theme touches on all three. So this theme that, hey, these assets are dissipating, we need to get them now, that speaks to both the facts and the law that's necessary to show when you need ex parte relief. So here you can see in this particular paragraph, the theme came out as thus: the inventory, fixtures, furniture, and equipment, and other assets of Acme are all that are available to satisfy Acme's debt to judgment creditor, reminding the court of this theme and of the importance of what's going to happen if the court doesn't grant the relief that we're seeking. The further argument about exigency, and you can see this is a specific point because we're making the point that there isn't enough to satisfy the judgment except for the asset. So we're applying that point in this particular scenario and using it to bring up the theme again. If Acme's members sell the business's assets at any price and take away the proceeds for themselves without satisfying the debt, judgment creditor will lose all practical ability to have this adjudicated debt repaid. Bam, bam, bam. There's the theme again, right? And I think we have one more example here. Yeah, I believe this was closer to the conclusion. This may have been the very end of the argument section, talking about the fire sale that's about to take place and how we're trying to stop it. And then we're reminding the court, should the court not grant this relief and allow the fire sale of the company's assets to go through, here's our theme again: judgment creditor will lose all practical ability to collect on the declaratory judgment, and the declaratory judgment will likely go forever unsatisfied. Right? And it's different ways of saying the same thing in different contexts. But by weaving that throughout, you give the reader a very definite takeaway, and they're able to say in 1 or 2 sentences what your 10 or 12 page brief was about. And that's a very powerful thing to be able to do.
And I also just want to point out and tie this back to the example I was giving of the different judicial fears and how your theme doesn't have to be overly complicated. It actually can be quite simple. That theme that Michael was highlighting and continuously reiterating is this theme of fundamental fairness between the present party. And it's quite, but it's actually powerful when it is continuously repeated and when it's not overstated. Some of us think a theme has to be about fist banging and about villainizing the other party. But what was especially powerful, I think, about the way that Michael had just presented that theme is it really was about fundamental fairness to a particular party, what that one party needs to be whole, to be remedied. And so I think that that's also another point. Your theme is weaker sometimes when it's all about characterizing another party rather than having an affirmative story for yourself, an affirmative reason why you are present before the court.
Right. We could have taken the theme another entirely direction, like, shame on these judgment debtors for not paying their debts. They're a bunch of bad, awful folks, and the court should punish them and send a message by entering this order. Okay, well, now you've kind of lost logos, pathos, and ethos, right? You're no longer really on the facts of what matters. That doesn't touch anything on the exigency, so you're losing on the logos part and your need to make the legal showing. And then, of course, you've also just lost the whole ethos argument that Erica was just pointing out, whereas, in the way that I showed it, the ethos argument is this is a judgment, and the court, should adopt a public policy that allows for judgments to be satisfied. And if a judgment is just a piece of paper and it doesn't get satisfied, that doesn't create good policy. That's not fundamentally fair, right? So thank you for that.
And just to piggyback, because I think this is such an important point, and it's eventually gonna go in as we talk about writing your facts. When you also base a theme off of a characterization of another party, your theme is susceptible to attack because all the other party has to do, they're the one with the facts regarding their own conduct. They're the ones that are going to be able to describe what they did or did not do. And so you actually might end up losing your theme a bit because all they have to do is put up some facts that prove you wrong, prove your theme to be wrong. They're not horrible people. Okay, so now all of a sudden you've lost a little bit of traction in your ultimate theme.
Right. Yeah. The unassailable theme is kind of a great point, and you're absolutely right. When you make it about character, there's always multiple sides to a character argument. Great point. All right. I want to be nice and efficient. Make sure we get through all our topics here. Point headings and tables of contents is sort of the next topic here. We're kind of funneling down from big to small throughout the course of this presentation, right? So we sort of started with the big questions, your audience, your theme. Okay, now we're kind of moving into the architect phase, and this goes a little bit into the Carpenter phase, but this here is primarily an architect question of what are your point headings and relatedly your table of contents going to look like. So let's move on to the next slide here. So your point headings, I think we all know what those are. They're the headings that may be anywhere between a couple of words and a big long sentence that provide essentially the outline and the heading structure for your brief. The purpose of point headings, they bring organization to your brief. When you set out a point heading, you set up an expectation that all of the prose underneath that point heading is going to be related to that point heading. That seems obvious to say, but what it does is it forces you to put like thoughts with like thoughts. And that's a very, very important and valuable thing, right? Setting out point headings also forces you to think about how your arguments all fit together. When you're able to look at your point headings, and of course your table of contents, by the way, is just a one-pager of your point headings, and you're really able to see, do these arguments fit? Is everything at the right level of indentation? Are the high-level points really the high-level points that I want to be making? Along with good umbrella paragraphing practice, which we'll talk about in a moment. And then I think I just made that third point, and Erica made it earlier too. The table of contents provides a roadmap for your brief Oftentimes, I've seen judges that's the table of contents of the briefs is the last thing the judge will look at before they go into the hearing to remind themselves of all the different things, all the different arguments the parties made. So point heading / table of contents is very important. So let's talk about what makes a good point heading. And the biggest point about the point heading is it contains the substance of the argument. It's not just defendant breached the contract, right? Well, that's just a legal conclusion, and that doesn't really get to the heart of what the actual argument is, right? So I put because here because the word because can be one of the most important words to use in a point heading. Legal conclusion X because fact Y. And when you put the because in there, it forces you to put the fact Y, and that makes it specific to the case. So that it's not just a general boilerplate point heading, but that again, it says something about the facts and the parties before the court at the time. One principle of point headings is every point heading in a particular sub-level should have the same structure. So if you decide that your A, B, and C are all going to be sentences, A, B, and C should all be sentences. It shouldn't be A is a sentence, B is a sentence, and then C is just the word sanctions, right? You want to make them similar because again, you're laying out this blueprint in your reader's mind, and you want them to understand what the like is with the like, and what your how far in, what level of indentation, shall we say, what level of nesting your thoughts are. Simple structure sentences, A because B is probably about as complicated as you want to go. Simple structure, if you get into a lot of subsidiary clauses, careful of although, things like that, careful of using a bunch of semicolons to make it really long, keep it straightforward. And then of course, not too long. I think, 3 lines is the absolute max that you want one to be, but most good point headings will probably be able to be a maximum of a couple of lines. Quick tip, different jurisdictions have different rules about when you must include a table of contents versus when you can simply choose to include a table of contents. My best advice is include a table of contents for all except the shortest of briefs. It is the roadmap. The judges and law clerks use it for all the reasons we've discussed. So even when I have a little 5 or 6 pager, in LA, you don't need a table of contents unless it's over 10 pages. I still put one in. Brian Garner, big giant in the legal writing world. You may have heard of him. He's great. Read his articles. He knows what he's talking about. And he is on a crusade to kill an old habit in the legal world, which I believe exists from the typewriter era. And it was what allowed a point heading to be set off from other things. They would capitalize every single word in the point heading. And Brian Garner's tip is don't do that. Brian Garner's tip is just make it a sentence, because I don't know about you, and I put very bad. I may have been exaggerating a little bit, but to my eye, it is very bad. I'm trying to read this sentence and my brain is stopping every 5 letters or 8 letters because I see a capital letter and I think, oh, this is an important word. But they're not all, you know what I mean? It's a sentence, and our minds are used to reading sentences as such. So happy to hash that out with anybody who wants to, argue that with me, because I definitely have had lawyers argue that one with me before. But this is my personal take on it. Take it or leave it. Okay, I guess I'm going to keep going here. We're going to talk now about introductions. This is really getting more into, now we're actually drafting. This is your Carpenter phase, when you're actually putting the sentences together, causing it to flow, and the introduction is right off the bat. So I'm going to give everybody who's there, just take 30 seconds and read this, and as you do, just think to yourself in your head, or make a list in your mind of what are the reasons why this is ineffective. So I'll just give it a very brief few seconds so you guys can read this and think about why this is not an effective introduction. So this is, if you couldn't figure it out, it's an opposition to a discovery motion. And I think, some of the reasons why it's ineffective are pretty obvious. There's nothing case specific in here. This could have been written about anybody's case, anybody's situation. And in fact, I think this was at least AI was used in the making of this, which we can talk about separately. So, you know, just be very aware, because oftentimes it really does take that human touch to make the introduction effective and engaging. But if I'm a judge or a law clerk and I read this paragraph, I feel like I've kind of just wasted 30 seconds of my life, right? I've got nothing from this that's going to help me decide, hey, which side really has the stronger argument here, right? So here is hypothetically from the same motion, same concept. This is in hang on. No, actually, this is a different type of motion. So, you know, just forget about the prior one. This isn't from the same one, but take a second to read it. Same deal. And think about what makes this more effective. So obviously it's got facts, right? Right off the bat, 10 months of meet and confer efforts it took us to get the responses that we're talking about. And once again, it funnels down to what ended up being the theme of this brief, which is from the sentence about 2/3 of the way down that begins with, in other words, it says, but for Patterson's motion, she would not have obtained the discovery responses at issue. And that is the theme of the brief. Very simple. But again, it's got a little bit of of all three of those prongs, logos, pathos, and ethos that we talked about. We made that point throughout the brief. And if I recall correctly, yeah, this was one where the court actually did impose the full requested amount of sanctions based on this argument. So that's an example of a more effective introduction because it uses the facts, it gets the theme in there, and it has a little bit of pathos, logos, and ethos kind of built in. One question that comes up while we're writing introductions is party labels, right? When you name the party in full and then you open a parentheses and you put in quotes what that party label is going to be. This I picked up from district court clerking, the idea that it's perfectly fine to omit party labels altogether if it's clear. If your only two parties are Smith and Jones, and you say Joe Smith and Mary Jones in the first paragraph, I guarantee you that you can just go right ahead and start referring to them as Smith and Jones, and nobody's going to be confused about who you're referring to, right? Yeah. It's okay to omit your party labels from the introduction, and maybe introduce your party labels in the background section. If you're just trying to get into a flow and you don't want it to be visually and syntactically broken up by a bunch of pauses to say a technical point of a party label, that's fine. Get your introduction out and save it for later. This next one's a really, really big one for me, and this really goes to, again, to keeping your audience in mind, the busy judges and law clerks. You are creating additional mental workouts. You are requiring additional mental workouts from your reader the more acronyms you use. Now, obviously, some acronyms, you know what they are. DOJ, fine. Okay. You know, RFP, fine. With plenty of acronyms that are just terms of art, industry terms. That's not what I'm talking about here. I'm talking about you've got a client that's got a 4-word corporate name and you shorten it to PQRS or something, right? And now you've got another one that's a different one. It becomes very, very hard for a reader who has a half a day to fully dive into your papers and remember this acronym means this, that acronym means that. And then, of course, it gets even worse when two different parties are using different acronyms for the same party. So avoid them where possible, even if it ends up being a slightly awkward, you know, 2-word phrase that is extracted from a longer title. Words are easier for the brain to connect to meaning than acronyms are. And then the last question is this question of proper nouns or positional nouns, meaning do we refer to the parties as Smith and Jones throughout the brief, or do we refer to them as plaintiff and defendant? And I think in your more rarefied courts, your appellate courts and your district courts, they like to use the proper nouns because it's a little more personal and it seems a little more specific. However, I will say that from my experience in state court, when we're very busy for a demur or a motion to dismiss, for example, sometimes it really is easier to just use plaintiff and defendant throughout, because I, as the reader, know defendant is always referring to the person who's moving and asking the court for the relief of dismissal. The plaintiff is the one opposing it. If it's Smith and Jones, my brain actually has to do an extra step. So it's a case-by-case basis, but it's just an argument for considering that using the positional nouns, plaintiff, defendant, propounding propounding party, responding party, whatever the case may be. That may be appropriate at some times. Erica, this is you, my favorite slide.
This is our favorite slide. Now, I don't want to lose any of you because you're looking at us going, wait, why is VH1's RuPaul Drag Race highlighted right here? And I promise we're going to bring it all back. We're talking about the facts section here and building out the basic narrative, which definitely ties into theming and how do you frame the facts. Where you start your story matters. How you place your client and their conduct in a favorable light, it matters. The reason we pull RuPaul in is there is a classic saying on the show consistently, all tea, no shade, which means I'm just telling you the truth. And if I'm just telling you the truth, I'm not being catty. I'm not being dramatic. I'm not gossiping. I am just telling it to you as it is. And I always recommend this. I teach students appellate writing, and I always recommend to them that you don't want to be over dramatic when you're talking about your facts. Part of gaining credibility with your reader, your ethos, is telling the facts as they are. And that's part of why we say show, don't tell. I don't have to tell you. I should not need to tell you about the other party. I'm just going to tell you what happened. And that's going to immediately cast the other party in the light that I want them to be cast in. And it's a much stronger position to advocate from, because as we were talking about earlier with theming, if you're going for characterization, if it's all about telling you what to think about what happened, telling you what to think about the other party, then you are subject to attack. Where if I'm just telling you the facts, if I'm just telling it to you as it happened, you are much less susceptible to the attack, because this is what occurred. And now the reasonable conclusion of how you want to characterize that behavior becomes obvious. And so we're going to give you, I think on this next slide, this is an inflammatory example of how you might see some facts read out, but it's a fun one, we think, because it really highlights the differences. So you don't want to say, Ms. Smith, a hardworking and devoted employee of DEFCO for 10 years, faced constant discrimination at the hands of her woman-hating supervisor, Mr. Doe. Okay, so that's telling the court, telling your reader what to think about Mrs. Smith, what to think about Mr. Doe, and characterizing the case, but you're not actually showing why any of that is true. And so it's better to say Ms. Smith started at DEFCO in 2013. During her 10 years of employment, she received stellar performance reviews, built a healthy client portfolio, and was recognized for training and mentoring new employees. Pause. Hardworking, devoted, right? Despite her qualifications, however, Ms. Smith has yet to receive a promotion. Rather, her supervisor, Mr. Doe, maintains a practice of promoting only male employees to higher positions in DEFCO. Okay, so that's the key difference between telling, showing. Showing is much stronger. Telling is subject to attack and it's weak. And when you think about it, because your narrative and your theme often go hand in hand, right? And so we were talking earlier about logos and pathos and ethos. And if you find that you've had to let go of logos, if you have to ignore several facts in order to make your theme, then that's probably not the right theme for you. Similarly with your narrative, if your narrative has to ignore facts, or if your narrative has to misconstrue the facts or add extra spin to it in order to prove the narrative that you think you're wanting to build, then it's probably the wrong narrative. It's probably not quite accurate. Now, of course, if you are a plaintiff's attorney and you are preparing a complaint, that's going to be very different, right? You're pre-discovery. But we're talking much later on, as you're further down the road, as you have your discovery, as you're perhaps now in your summary judgment motion. The point is you should be able to look at the facts, tell them almost objectively, and they should tell the story, tell the narrative that you are pushing. If you can't objectively tell your facts or wholly tell your facts and build that narrative, then it's not the right narrative. So we're going to talk also about organization. The principle of tell them what you're going to tell them. You're going to then tell them. And then you're going to tell them what you've told them. So this is CREAC, IRAC. We all know this. This probably haunts many of your dreams, but it is still so valuable. And it's also, listen, your entire brief, as Michael was explaining, when you think about the 5 different sections of a brief, typically, right? Introduction, background, legal standard. It is operating, your brief operates as this overarching IRAC or overarching CREAC. And then each section has its own bit of a IRAC or CREAC structure. And each paragraph might even also somewhat have its own IRAC CREAC structure. And everyone knows IRAC, just in case some of us aren't familiar with what CREAC is. It is your conclusion, rule explanation, analysis, and your conclusion again. So it is actually, you are starting with your conclusion. You're starting with the ultimate point. Your rule explanations, your analysis, and then again, your conclusion. So you're telling them what you're going to tell them. This is what I'm asking the court for, or this is the conclusion the court should reach, right? And then each step after that.
And a very common mistake, including one that I see with experienced litigators, and you look through your briefs because it's relatively easy to spot once you see it, is if you got a point heading and you're about to go make a point, and directly below that point heading, you jump into case law or you quote the case law or you're talking about the rule, stop and think. Are you really helping your reader as best you can there? And the answer is probably not, because you're skipping the I of the IRAC. You're skipping the issue before you go to the rule. You've got to contextualize the rule for your reader. Tell them what issue you are arguing. Now they know that. Now they understand why you're explaining them the rule. We're going to talk about umbrella paragraphs and road mapping. We are in the thick of the Carpenter phase right here, really building out brick by brick, piece by piece, getting it all there in a way that is most persuasive to your reader. Umbrella paragraphs are based upon this principle that Erica just mentioned. What is an umbrella paragraph? It is inserted directly before the first in a series of subsections to preview for the reader the points to come. What does that mean? We'll look at it in a second. The benefits of umbrella paragraphs is they're going to provide the reader with signposts. Again, you're going to tell them, hey, the 3 points that I'm about to make are A, B, and C. See below, A, B, and C. Okay, now when the reader's reading through A, B, and C, they're going to, these are the points that go to the 3 factors for, whatever legal conclusion you're looking for. It forces the writer to maintain an organized approach. If you're in your umbrella paragraph, and I'll show you where it is in a second, if you're in your umbrella paragraph and having trouble articulating it, then that might be a signal that you actually have to take a step back to your architect phase for a second and say, hey, does my outline make sense here? Do the things that are A, B, C, and D really need to be A, B, C, and D? Or maybe it actually needs to be A and B, and then the C and D need to become a 1 and 2 indented under the B. And when you force yourself to write your umbrella paragraphs, it can reveal these potential weaknesses in your structure. It also, again, just like the IRAC format that we just talked about, it forces you, the writer, to contextualize before you jump into the argument. Very important for the reader who doesn't know your argument and needs the context of it first. It also is very important because it will illustrate the logical connections between upcoming subsections, right? So if you've got 3 elements that you have to show, then your umbrella paragraph can indicate, hey, our client wins because the other side can't show any of these three elements, or maybe our side wins because we can show all three of these elements. And so you use the and, or maybe you're in a series of factors and you can say, all of these factors support all 8 of these factors. Well, maybe not 8's quite a bit, but all 4 of these factors support the conclusion that we're going for. And then, you go into the 4 factors. So let's look at an example here. This is a argument section of a summary judgment motion that we were plaintiff for and we were opposing. Hopefully, I hope this contains some decent examples of point headings and how the argument, the kernel of the argument exists within the point heading. So I mean, even right, you remember that we talked about that earlier. So you can see right off the bat here, there's a because in there, right? But that's not what we're talking about right now. What we're talking about right now is the umbrella paragraphs and where they go. And so these arrows would be where the umbrella paragraphs would go in this particular brief structure. Below a high level heading, before the first of a series of subheadings. So the first example here is the one that just turned purple. We're going to put a umbrella paragraph right underneath this point heading 1, and it's going to preview point headings A and B. So what might that look like? Here's an example. Again, the two points that we're previewing are A, the operating agreement is not authentic, and B, the operating agreement did not govern. So here is our point heading. Here's our umbrella paragraph that would introduce these two. Both the authenticity and operativity of the purported LLC operating agreement is materially disputed here. Substantial evidence shows that the purported operating agreement A is not authentic, and B, based on the party's intent, was not the operative LLC agreement, etc., etc. Each conclusion is an independently sufficient basis on which to find that the issue of plaintiff's membership can be resolved only by a jury. Right now, that sentence is that to me is a great place. The umbrella paragraph is a great place to put a sentence like that, because it's telling you, court, hey, court, I'm about to tell you A and B. And if you, court, agree on either A or B, then my side wins. Hugely important context before we start talking about what A and B are exactly, right? So I'm going to do one more example of this. This purple is where the point heading for the overall A, B, C, D structure would go. It's going to appear right below the heading for the overall argument section, and it's going to preview all 4 of these. And this is an example of how to do it without necessarily needing to go A, B, C, D, or use, a very sort of parallel structure. This is a little bit less of a parallel structure, but here's how it would look. Procedurally and substantively, this motion is without merit and should be denied. Procedurally, the motion runs afoul of due process by violating statutory rules for providing notice of summary adjudication. So that's letter A. Substantively, the issue of plaintiff's membership in the LLC is amply triable. That's letter B. And neither the ultra vires doctrine, that's letter C, nor any of defendant's other arguments, that's letter D, alter this conclusion. So you can see this is just another example of you're previewing the 4 points to come, and then your reader knows exactly where they are when they get to them. Right, I think we are coming along just fine here. I'm going to talk about a few paragraphing principles, and then Erica will start talking about some topic sentence stuff. So this is still mostly Carpenter phase, but this is also certainly getting into your judge phase too. You've been doing a lot of drafting. Now you're going back and saying, hey, are my paragraphs logically grouped? Do my sentences flow from one to the other? Really, really getting into this line level editing type of stuff. So what is paragraphing? To me, paragraphing is the intentional use of paragraph breaks to organize the writer's thoughts and increase clarity and meaning for the reader, right? The paragraph is sort of the middle-sized unit of thought. The sentence is the smallest unit of thought. The paragraph is the medium-sized unit of thought, and the section is the large unit of thought. So the paragraph really functions as the bridge between your micro-level writing and your macro-level structure, and it's actually a really, really important principle, right? So principles of paragraphing. One overall thought or point goes into one paragraph. A paragraph needs a topic sentence, Most of the time, it makes the most sense for that topic sentence to be at the beginning of the paragraph. Sometimes it is stated or even reiterated at the end of the paragraph. And hopefully you might catch a glimpse of how this relates to the CREAC and IRAC structure that we just talked about, right? Your C of CREAC, conclusion, your I of IRAC, issue, that's your topic sentence, right? That's letting the reader know what it is you're about to talk about. So then once you lay out that topic sentence, then the next principle of paragraphing is that all of the other sentences in your paragraph have a clear relationship to the topic sentence. And oftentimes when we're having trouble with making a paragraph flow and a paragraph seems choppy or disjointed or not, like it's not hanging together, this is one of the first things to think of. Where's my topic sentence? Okay, there it is. Okay, now here's all my 3 or 4 other sentences in the paragraph. Do each of them truly relate to the topic sentence, and how? And then, of course, your last principle is avoid overlong paragraphs. Certainly no more than about a page. If you've got a paragraph that's going along, a page of double spaced legal writing type, you've probably got multiple ideas going on in that one paragraph, and you want to consider where to break it up. Archetypal paragraph types. And if we had more time, we go through more examples of these, but this is an overview right now. So one of the clear paragraph types is, there are 3 reasons why, the court should do a particular thing. And then you simply list them out: first, second, and finally. Very clear paragraph structure. You've made very clear how your 3 subpoints relate to your initial point, right? Another archetypal paragraph 5, a topic. This is kind of like the CREAC kind of a thing. You say, hey, here's a conclusion that we want you to adopt, court, but why should you adopt it? Well, the law says this. And if the law says this, it means this particular sub-finding. But here, there's also this fact that it interacts with this law, and therefore this fact taken with this law leads to this conclusion, right? A series of if-thens that sort of leads you to your conclusion. You might have a paragraph type that is, for example, a breakdown of a particular case that's particularly apposite, or maybe inapposite. You're taking a paragraph to describe why your opponent's description or application of a particular case is incorrect. So you'll say, hey, defendant's use of the Smith case is inappropriate here, and then you explain why, right? And then a hybrid of the different types of, different paragraphs will incorporate different structures. So Erica, why don't you show us how we can work on topic sentences and put them front and center?
So where I see especially a need for topic sentences is oftentimes where we are elaborating on various cases. And I use these examples with my students. And so this specifically came up in the time when Rahimi, a Fifth Circuit case regarding Second Amendment rights, was before the Supreme Court. That's been decided. So if you're looking at this going, this looks like this has been a settled issue, it has. But I think this is a helpful sample. And so we're going to show you one example and then show you another. And it's, to be clear what this is, right here is not bad. This isn't bad writing. This might actually be what your first draft with your Carpenter looks like. And the next sample isn't going to be your model where it's not necessarily perfect, but it is an example of how you are going to, with your judge's help, start to elevate. And specifically in this situation, take your topic sentences and bring them front and center. So if you take a few seconds to read this, while you read it, I just want to call out that you'll notice each paragraph begins with, in this case, the court decided this. Each of those paragraphs contain facts about the case. They go somewhat into detail about what the court ultimately held and then give you the conclusion from the court, right? And you see that in Boyd, the Third Circuit considered a challenge brought by an individual subject to a domestic violence civil order. In Bena, the Eighth Circuit also considered a challenge. Here, petitioner, like in Boyd and Bena, is subject to a domestic violence order. Again, this isn't bad. This is oftentimes where we might start. But what we're missing here is actually the takeaway from the case, the principle from the case. We've placed so many somewhat unnecessary points into the paragraph that we've buried the entire purpose of why we are talking about this Third Circuit and Eighth Circuit case. So let's go to the next one. Okay, more effective. Of the 3 circuit courts of appeal to address the constitutionality of Section 922G8, 2 have found the statute historically supported by a tradition of regulating dangerous persons or non-peaceable citizens. Oh, okay. So that's the purpose of why we're going to be talking about this Third Circuit case and this Eighth Circuit case. And again, if you look now, it's now all boiled down to one sentence. And boy, the Third Circuit found longstanding historical support for the principle that the legislature can limit dangerous people's access to guns. And similarly, in Bena, the Eighth Circuit cited a historical record of disarming non-law abiding and responsible citizens to conclude that the Second Amendment was a right enjoyed only by peaceable citizens. I've essentially I took out all the unnecessary facts, the court's reasoning necessary. Well, I got straight to the points, the court's reasoning, right? And I've highlighted the point about dangerous people and peaceable citizens. And so now Section 922G8 is thus well supported by a historical record of regulation and consistent with the public understanding of the Second Amendment's unqualified scope. And there it goes through and it shows you that what we have here is a not peaceful, non-law abiding citizen. And therefore, that is why the legislature has the right to limit the Second Amendment. And so
can I just point out that if you read those 2 bold paragraphs, just the one followed, bold sentences, just the one followed by the other, you have a distilled down version of exactly what the argument is.
that is exactly right. And I think that this is actually, if we go to the next slide, we're going to say that's exactly it. Where a great test for you is if you just read the topic sentences of each of your paragraphs, is there a flow? Now, this isn't a hard and fast rule. The second you see one sentence that's a little off from the other, it means it's wrong. Maybe not, but do you have a general flow, a general sense of your argument if you just read each of your topic sentences? And if the answer is yes, then you have some good topic sentences there. You have some clear organizational structure. The other thing I will just highlight, because topic sentences, there's an art to figuring out what sentence is your topic sentence. All of us write topic sentences. Some of us, though, bury them in different places in our paragraph. Now, the 2 I tend to see the most, probably the one that's most common, is it's your last sentence. We treat the thesis as if it's a present that we're unwrapping. So we take off the bow, we undo the paper, we open the box, and here at the very end of the paragraph is the whole point we were trying to make. Not as out, right? But it's true. It's true. We almost treat it like it's a gift we're giving. It's actually not helpful. It's not, quite frankly, a gift when it's buried at the very end. It's a gift when it's given at the beginning. And another one, I was this kind of a writer. My topic sentence always tended to appear as the second sentence. I would have what was almost like a throat clearing sentence before I actually got to my real point. Once you identify, if you're not already programmed to put your thesis sentences, topic sentences first, if you're not already programmed to do that, figure out where your topic sentence usually hides in your paragraph. It's probably in the same place each and every time. And once you know it, well, then it's really easy to write the paragraph, I'm just going to go to the second sentence. There it is, popping it up. Oftentimes, that's all you really have to do. So another point we're going to talk about is parentheticals. When to use them, when not to use them. I think this point sometimes goes hand in hand, parentheticals with footnotes. In some instances in writing, you're using footnotes versus a parenthetical. Parentheticals do break up your writing, of course, right? So you want to be strategic about how you use them. Don't use them to make really important points. if you have a parenthetical, you want to think about it as it's bringing extra support to the point you just made. One example I have of this is if you have distilled a rule into your own words, well, then it might make sense that you provide the case site and then provide a quoted rule from the court, just so that way the judge or the clerk who's reading this can see that you're not making up the standard. It's very clearly articulated here by this court in this other way. Put the point that you're making first. Don't rely on the parenthetical to make the point for you. So have the overarching point in your in the body of your writing. We've also talked about, Michael and I talked about this quite a bit. What's the value of this parenthetical? Case quotes tend to be valuable than writer-generated parentheticals. Again, this isn't a hard and fast rule. There are times where you do need a writer-generated parenthetical because you're using the case to say that the facts are analogous or whatnot. Okay, then perhaps you're going to need the generated parenthetical, but the case quote is oftentimes the most valuable use of the parenthetical. And then when we're talking about string cites, why are you string citing cases? Are you just simply trying to say that a lot of courts agree with this? It's so, e.g., CG works fine in some instances. Signals can help boost that point. If you are trying to make the statement, one example would be the different ways strict scrutiny is used, or strict scrutiny is used in all different contexts in the law. And so then you want to have a parenthetical that it's not going to be a case quote, but it's going to say equal protection, race, national origin, First Amendment, or so on and so forth, fundamental rights. And then you're going to have a case for each of those to just prove up the point that this comes up in many different contexts. And so your parenthetical is really just a short 1 or 2 words highlighting that specific context. That's great. Michael, I know you also have some thoughts on this. So
on strings or just on parentheticals in general?
In general, if you had anything you wanted to add here.
Yeah, just to everybody review your blue book and make sure you know exactly what each signal word means before your parentheticals. The word see does not mean go look at this case, right? It means that this has a very specific meaning. It means that the following proposition strongly supports, or the case and the things inside it strongly support the thing that I just wrote in the body of my thing. Check what CF means. We're running a little bit out of time, so I won't go into detail right now, but CF is another one that's commonly misused compared to what the blue book says its actual purpose is.
Yeah. And then I think this is just one of our final thing close to the end here. One of our final points is just that good parentheticals increase your credibility. So putting your arguments, putting your rules, your case analysis into your own words, but then using a parenthetical, like a quote, to cement the fact that you are not making this up, that this is the law or this is what the court decided. That's helpful. I will also caution, though, that you can lose credibility in your parentheticals, because if you represent in a parenthetical that a case says something or stands for something, and then your clerk or your judge goes and looks at that, most likely your clerk goes and looks at the case and realizes that that is not correct, or you really cherry picked one line out of the case and it's totally out of context, that's going to really diminish your credibility. And all of a sudden you're going to have your clerk on guard and wary of the other points that you're making throughout your brief. So credibility is huge. Be mindful of it, because it takes a lot to gain the trust of your reader, but it is very easy to lose it.
Right. I'm going to take 2 minutes and go through my quick little bonus stuff, and then I'll give us just under 10 minutes for questions that anybody has. So if anybody has questions, make sure you're using that Q&A to submit them now, and we'll go through them. So three tips for sentence level clarity. Principle number 1, 99% of the time, it is best to place dates and time-limiting clauses at the beginning of the sentence. So this goes to your facts section. Go back and look through some factual background sections and some briefs that you've written. Look at all the sentences where you have a date phrase. On January 1st, 2023, where is that date clause? Is it at the end of the sentence? I challenge you. Put it at the beginning of the sentence, put a comma after it, and now read that new sentence and tell me that it's not a little bit clearer, right? And this is a great example. I rewrote the principal sentence in breaking the principle. If you put, it is best to place dates and time limiting clauses at the beginning of the sentence 99% of the time. That's a little less clear. We're not really sure what the time limiting phrase 99% of the time is referring to, right? This is another big one. I could probably do a whole hour on this one. And this is particularly a quirk of the English language. And this is really great for when you're trying to land your perfect 10 gymnastics flip and really land your point. Think about what the strongest or most important word in the sentence is from your argument and see if you can reorder the words to put that word last. So I gave you an example again using the principal sentence. Typically, the strongest word in the sentence is the very last. And you can see what that does, right? The reader's like, oh, what's the strongest word in this? Which one? Oh, the last. Boom. Made my point. If you flip it around, the last word in each sentence is typically the strongest one. Okay, you've communicated the same meaning, but it's not as punchy, right? The most important word is no longer the last word, and so your mind almost has to do a little backflip to make it make sense. And the last one, be chronological where possible. Put things in time order. And so you can just see I did a good, better, best. First version, maybe this comes out during your first draft. This case was transferred from Department 70 to Department 72 pursuant to plaintiff's statutory peremptory challenge on date. Okay, well, then let's apply tip number 1. We put the date at the front. On December 5th, 2024, this case was transferred from Department 70 to 72 pursuant to the peremptory challenge. Well, fine, but chronologically, the peremptory challenge came before the transfer, right? So we rewrite it to the best, we put them in order, and that's the one that is kind of clearest and easiest for the reader to follow. So
I
there's
love how Michael, I was just going to say, I love how Michael showcased the evolution because all of these tips are truly your judge. That's your judge's role, is to come through and make these little tweaks and these little changes to each and every sentence and to be so detail oriented. And so I love how Michael showcased the evolution of how your writing and your drafting will go, and especially once your judge is involved.
Mm-hmm. So we have a few minutes for questions, and I believe that Nina is going to be moderating some questions for us. So Nina, if you have some stuff for us, we're happy to discuss.
Yeah, absolutely. There certainly are some questions. Thank you so much. And we will go ahead and move on to your questions. So the first question that we have is from Gretchen. They ask, when there's no table of contents in what I have written, do you think it is helpful to a reader to instead look to the bookmarks if the PDF is formatted to potentially display those upon opening?
I wouldn't depend on that because, I mean, even as recently as a couple years ago, there's judges who do everything via courtesy copy, first of all. So, with one of the judges who'd been doing it the same way they did it for 35 years, I'd get a stack of the daily calendar delivered in a folder to my office. So I wouldn't rely on the bookmarks, especially since when you think about a public filing, the bookmarks aren't going to be on the public filing. And yes, many courts have local rules that say you need to bookmark your exhibits and things like that. But I wouldn't necessarily, bookmarks are great, certainly use them for your exhibits, but I wouldn't consider them a replacement for the table of contents.
I think that's right. I think it's definitely a clever idea if the brief is short, and so to the extent that you have a clerk, they might rely on it, but I wouldn't guarantee that it is going to be a true way of replacing the table of contents.
So thank you both for those thoughts. This next question is from an anonymous attendee. They ask, as law clerks, how did you think ad hominem attacks in the lawyer or party resonate? Did it influence you one way or another? If not, why? What are your thoughts on that in general?
You want to start this, Michael?
No, you go. You go. I know.
No, I know. No, I don't find, I never found them, quite frankly, I don't think I found them ever useful. Oftentimes as a clerk, I really want help from the lawyer in figuring out what the law is and what the best outcome is. And so there's precious space and wasting space. It's not going to help me in drafting my order. It's not going to actually appear more persuasive to me. You're dealing with opposing parties constantly. So I don't find it, I never found it, quite frankly, useful. Sometimes I found it frustrating. What about you, Michael?
I think this is a perfect example of the application of all tea, no shade.
All tea, no shade.
Ad hominem attacks are shade. It's the other side is a liar and a cheat and a fraud. Okay, well, that's ad hominem. But if you show, okay, look, court, here's the discovery response where they said X, and then here is their deposition transcript where they said the absolute opposite of X, and here is a document confirming that the deposition transcript was true in the discovery. Okay, now you've shown the tea.
Yeah.
You're showing, not telling. And so, you know, that it's still accusatory. We got to do that sometimes. You might be going for terminating sanctions. A party has just, you know, made a mockery of the judicial process throughout. And so that, you know, you need to make accusations. But again, it's through that lens of do it with the facts, do it with the showing, not the telling.
And one other point I'll just say, the attacks especially don't work on counsel. When it becomes just mudslinging at opposing counsel, I find that also incredibly tedious, and I also am not persuaded. If anything, I find it cuts down your credibility, because as the court, judges in most instances really don't want to see the parties appearing before them. They really want the parties to be working it out and reasonable and acting civil towards one another. So we don't want to see the dirty laundry.
Yeah.
Thank you both for that insight. Definitely helpful for drafting. Our next question is from Scott. They ask, have the quote unquote floodgates ever really opened? Can you give a real world example if you can think of one? It's a common fear, but when has it ever really come to pass?
That's so, I think where you see, so right off the top of my head, here's where I will see the floodgate argument. I think that's actually a really good point. I think where you see the floodgate argument appear is in the context of how broadly are we defining the scope of liability? Or you can see it in causal chains. How far down the road are we going to say that one person's actions is attributable to ultimate harm? And well, I guess I can also just give you, a real practical example of floodgates are sometimes statutes are passed. So if you are litigating in California, statutes are passed that as they are written and then interpreted by courts can open the floodgates to tons of litigation. PAGA is a huge one of them that just recently got revised, narrow the scope of standing, because what was while maybe originally crafted with the best intentions as a private attorney general statute, ultimately brought on a whole slew of litigation that created duties and responsibilities and liability well beyond, I think, what was initially imagined, because of how it became such a widely used tool by attorneys. So that's one example I can think of where it is a statute, and the interpretation of that standing requirement, how it got and broadened, ultimately then resulted in the legislature coming back and narrowing the scope of this. So, but I do agree. I think the word floodgate tends to be a bit hyperbolic. So, but you can certainly see where there are ways of explaining that if you pass this, it's going to affect a whole bunch of parties, and it's going to broaden the scope of liability, or create there isn't going to be a limited principle. And you see that appear. Courts use that word limiting principle constantly. Michael, do you have thoughts?
The only thing I'll add is, whether or not any of us personally believe that litigation and judicial opinions and decisions lead to floodgates, judges certainly do. Health judges tend to think of themselves as relatively important types of folks. So they're concerned about floodgates. So again, from a results-oriented perspective of getting the result for your client, the point is that the judges are interested about that floodgates concern, not necessarily some statistical analysis of how often the floodgates effect might actually happen.
Thank you both for that perspective. Our next question is from Leslie. They ask, what do you think about using AI to organize the argument or develop the theme? What are your thoughts on that?
We avoided that AI topic. We specifically said we were going to leave that out of this talk because there was already enough to talk about. But repeat the question one more time because it's a specific question. It's about for two particular purposes. Say it again.
Yes. So the question was, what do you think about using AI for drafting or specifically for creating the theme?
Okay. Was there one that was organizing topics? Was that one of the things in there?
Let me find exactly what it was.
It was organizing the topics or creating a theme.
Yes, that's correct.
There's a lot of ways I could answer this, but as far as the first one goes, as far as for organizing the topics goes, I wouldn't, and it's not because AI can't do it. It's because of this concept called, I believe it's called cognitive friction. And there's been some really interesting articles that have come out about this recently about how our use of AI, not just legally, but our use of AI to do writing is removing this cognitive friction that takes place when a person has to really go through thought by thought and stitch it all together to really understand what's going on. So organizing the topics, that architect stage of what order the argument should go in, I wouldn't use AI because you need to develop that muscle for yourself so that you can then do all the other phases of it. And if you're using AI to skip that cognitive friction that builds that muscle and that understanding, you're going to have a tough time finishing your brief. You're very likely not going to be as prepared for your oral argument because you're not going to understand your own argument as well. So I wouldn't necessarily use it to organize the topics, even if it could be good at that. Erica, do you have any thoughts about that one, or perhaps about the using it to help you figure out your theme?
I think I don't think it's going to be as helpful for either. To tie it back to our madman architect, Carpenter judge, you are using AI essentially to shortcut your architect phase. But as I was explaining, if you shortcut your architect phase, what's going to happen is your madman is going to be creeping into your carpenter section, and you're going to have a bit of a jumble happening, a battle between your creative role who's generating all these ideas and your carpenter role who's just trying to get a draft together. I think that the architect really serves a valuable role in this. And I think to Michael's point, that doesn't happen from just seeing an outline, that happens from creating the outline. It's the same thing when we went to law school, right? And professors would say, you can take somebody else's outline and maybe you'll get a fine grade on the final exam. But the truth is when you build out the outline for yourself, that's when you're actually going to have a better understanding of the material. You're going to have a better grade in the class realistically, just because you're creating those pathways in your brain and you're ingesting and consuming the material that you are generating and actually making sense out of it for yourself before you actually put pen to paper. And I think theme comes down to a judgment call. I know we use AI and it's getting better and better at that, but I do think there's just a human aspect about what is the best theme, what makes the most sense, what truly sings. And that there's a human judgment call in that I just don't think AI can fully capture.
Awesome. Thank you both for that insight. We have time for a few more questions, so I'll move through these fairly quickly. This next question is from Scott. They ask, in CREAC, is rule explanation a single thing, explaining the rule, or two separate things? So you're going to state the rule, then explain it, or why it's relevant, then analyze. What can you clarify for him what that would be?
This is you, Erica.
I think this can appear in a couple of different ways. Your rule statement can be the rule that you are making, and then it can be subsequently how it applies in cases, the different contours or the nuances in the rule before you get to how it plays out with the parties. I will also say that you might have an instance where you are using multiple paragraphs to prove up a point. And so you might have each paragraph where there is its own built-in rule or case explanation, and inside of that same paragraph, the application to your own case. This isn't it's not a hard and fast example. Just another way of, like, for example, you have a breach of contract case, right? Well, so we know the elements of breach of contract, right? Well, now we're going to talk about how this plays out, right? When you're going through each of your elements, you're going to have rules. Let's say you're using the element of plaintiff failed to perform their contractual obligations, and that's one of the first elements. Well, part of your rule is going to be, yes, plaintiff is required, that's an element of their case, but then what you also might have that kind of works in almost like its own rule before the analysis, the contract language. That actually becomes, in some ways, that replaces the need for the case or replaces the need for the additional rules. The contract language actually becomes the governing rule between the parties. And so there's different ways this all appears, but in some instances, it's just simply the explanation of what the rule is. It can be the explanation of the rule and and subsequently how that plays out in different courts. Or it might be all broken up if you have several factors that you want to prove of.
So thank you for clarifying that, Erica. I think we have time for one more question. Don't worry if you have more questions for them. You can always contact us and we can put you in touch. They will also hopefully be back for more presentations, so you'll get to see more of them. Our last question for today is, do you insert the umbrella paragraph in the table of contents or in the body of the brief? How would you recommend incorporating that concept?
Okay, thank you. Yes, and I can see by asking that question how my slides might have been a little unclear, and I apologize. No, the umbrella paragraph goes in the body of your brief. I put the arrows in the point headings because that was the easiest place to show where those paragraphs would go in your brief, as opposed to having to scroll through 8 pages on a screen share like that. But yes, these umbrella paragraphs are just part of your memorandum, part of your memorandum of points and authorities. And they go right there in the body as part of the overall flow. And you'll see once you start writing them, they fit very well like puzzle pieces into all these other principles that we're talking about. The IRAC principle and the paragraphing principle and all these things, they all kind of work hand in hand. But yeah, no, table of contents is just your point headings. And thank you for clarifying that. And I'm probably actually going to, whoever asked that question, I'm going to make a clarifying point about that in the slides for the future presentation, because I can see how you would think, oh, there's an arrow in the table of contents. So does it go in the table of contents? No, it goes in the body of the brief.
Thank you for that clarification, Michael. And thank you all so much for asking your questions and being here. Michael, Erica, we truly appreciate your time and answering all of our audience questions. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier today, if you're a lawyer attending, don't miss out on the Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile for free at lawyers.justia.com. And if you'd like to boost your visibility further with a premium placement that allows you to show up above the organic listings, you can go to marketing.justia.com to learn more. Thank you all so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.